Hello, my name is Chris Field and I'm your presenter. This video program will provide you with an understanding of the importance from the medico-legal aspect of completing the patient care record in a legible, accurate and comprehensive manner. Also, the possible difficulties that may be encountered as a result of failure to complete the PCR in that manner will be demonstrated.
Tell me, Mr. Deppler, did you attend at the scene of a motor vehicle accident on the 17th of May 1991?
Yes, I did.
Do you have any recollection of the scene of the accident?
No, not really. I've attended many accidents over the last 3.5 years, but if I could refer to the patient care record, it would assist me.
Please do so. Now then, Mr. Deppler, have you read the patient care record?
Yes, I have.
Do you now recall anything concerning the accident scene on the 17th of May 1991?
Yes, I do. We attended at the scene of the accident at the corner of Johnson Road and Northern Highway at 4:30 p.m.
How did you know it was 4:30 p.m?
Because that's the time that's recorded in the PCR.
When did you complete the patient care record?
Well, it's my practice to complete the PCR immediately the opportunity presents itself. Now, if there's time while the patient's being transported to hospital, I'll do it then. Otherwise, I'll do it immediately the patient's been admitted to the hospital to which they've been transported.
And that is your standard practice, is it?
Yes, it certainly is.
How do you know that you follow that practice in this particular instance?
Well, I don't really. All I can say is that that's my usual practice, and unless something untoward happened after we'd started treating the patient, then that's what I would have done. And having looked at the PCR, I have no recollection that there was anything unusual, and so I would have completed it either while the patient was being transported to hospital or immediately after admission to the hospital.
Thank you, Mr. Deppler. Now, can you tell me what observations you made concerning the patient?
Yes. The patient was lying in the roadway, bleeding from the right side of his head.
Was he drunk?
I don't know. There was the smell of alcohol in his breath, but I can't say whether or not he was drunk.
Did he say anything to you about how the accident might have occurred?
No, he was in an altered conscious state, not speaking.
How did you know he was semi-conscious?
Well, the note I made in the PCR is that he appeared to have suffered a head injury. He was bleeding from the head, and when I questioned him, he didn't respond appropriately, but he was making incomprehensible noises. So I concluded that he was in an altered conscious state.
Well, from your observations, Mr. Deppler, who was responsible for causing the accident?
Well, I can't tell you that. The accident had occurred by the time we reached the scene. All I can say is that the patient was lying in the roadway next to his vehicle. There was another vehicle on the other side of the road, but I don't know how those vehicles came to be in their respective positions.
You have just witnessed a scene of an ambulance officer under cross-examination. In that scene, he was able to answer all questions posed to him and provide accurate information based upon correct PCR documentation. The PCR serves a number of vital functions. For the ambulance officer, it is an aide memoir, a cue to observations, and a record of observations and treatment. It also provides a record for the hospital, and the ambulance service uses it both for general administrative and data purposes. Of equal importance is the contribution of the PCR to educational assessment, training needs of individuals or groups, and finally, clinical audit. The importance of completing PCRs in a legible, accurate and comprehensive manner cannot be overemphasised. Experience with the completion of PCRs has led us to formulate 4 important headings which summarise the manner in which you should complete PCRs and which will lead you to avoiding any difficulties if you become involved in the legal process. Factual, accurate, complete, timely. They speak for themselves, but I will amplify them a little to give you an understanding of what is meant. You can then use the acronym FACT as a memory prompt. Factual. You should record in the patient care record facts only. You should be cautious if you record opinions or hearsay. Opinions are conclusions that you have drawn from your observations, which may or may not be correct. Hearsay is repeating what other people tell you, which also may or may not be correct. When you record opinions or hearsay in your PCR, you should identify the source of that opinion or information. Otherwise, you may be open to attack by way of cross-examination. Accurate. This speaks for itself. You should accurately record what you see and do, and what you were told as just outlined, and no more than that. Complete. You must include everything that you observe, as well as everything you did, so that a full picture of the incident is presented. It may be that at some time in the future, you'll be asked to recall what you saw, and if a substantial period of time has elapsed since the incident occurred, the patient care record will be the only prompt for your memory. For that reason, you should make sure that everything relevant is recorded. Timely. The PCR should be completed as soon as possible after the attendance at the scene of the incident. It may be appropriate to take rough notes on a separate pad for later transcription. If it is not done until the end of the shift, which might be several hours after the event, your memory will be clouded by subsequent attendances, and you may not recall everything that happened, so your PCR will not be accurate and may not be complete. Even if it seems to be a burden, the patient care record should be completed during and/or immediately following the attendance. There are several common circumstances in which the patient care record may be subject to legal scrutiny. If the patient subsequently dies, then the PCR will be part of the documentation which is examined by the coroner on investigating the death. If he sees fit, he may require the ambulance officer who completed the PCR to give evidence at the coronial inquest, which may be held at a later date.
If there's time while the patient's being transported to hospital, I'll do it then.
The other common circumstance in which the patient care record is subject to legal scrutiny is if there is litigation arising out of the incident from which the patient suffers injury, or alternatively, litigation arising out of the treatment provided to the patient, either by the ambulance service or by the hospital to which the patient is transported. Solicitors acting for a patient who is aggrieved by the treatment received can obtain a copy of the ambulance service's records, which will include the PCR, by use of the Freedom of Information Act. The other manner in which the ambulance service's records may be obtained is through the process known as discovery when legal proceedings are instituted. The discovery process enables the parties to litigation to obtain all documents that are relevant to the matters at issue between the parties. If the ambulance service is a party to the litigation, then its solicitors will have to provide copies of the PCR to the solicitors acting for the patient. A copy of the PCR appears in the hospital records. If the hospital is sued as the result of the treatment provided to a patient, then the hospital records form part of the discoverable documents, and they have to be provided to the patient solicitors. In those circumstances, a copy of the PCR will also fall into the hands of the patient solicitors. If the litigation proceeds to hearing, the ambulance officer who completed the PCR may have to give evidence concerning the matters recorded in the patient care record. As litigation usually takes a substantial period of time to reach court, it is important that the PCR is accurately completed so that the ambulance officer has a clear recollection of what occurred if and when he does have to give evidence. We have already seen a case where the ambulance officer was shown in a positive light. He was able to clearly answer any questions from the PCR because he'd completed it accurately, fully, clearly and legibly. Let's look at a case where the PCR's completion is now the issue of some question and further thorough investigation.
want to take him down to resus.
Yes, that's all right.
How's his blood pressure going?
It's 180 systolic.
And how about his conscious state?
Conscious but confused.
We in? Yep.
Emergency Department, Roy speaking.
That's good. Nice
What
and
happened,
slowly.
An RTA on the freeway.
Right. Hello, can you hear me? What's your name? What's your name? What's his name?
Peter Armstrong.
Yes, he's here. No.
Peter? Peter, what happened?
I don't know.
You don't know. Okay, take a big breath in for me. Good. Right, his airway sounds pretty clean. Big breath in. And out.
Hello.
Peter. Not to worry, everything's okay now. Not a problem. Bye. Do you want a hand with that?
Yeah, that'd be great.
So, how's it going?
Oh, all right. You know, I don't understand these people. They drink themselves stupid and they expect to be able to drive safely. I mean, who are they kidding?
Themselves?
No Francis, I need to go to the truck for a check.
Where's the doctor? He's in emergency.
I need to talk to you.
Got a problem down the back. I'll be with you in a minute. Francis, this fellow down the back's deteriorating. I need to talk to Wayne. Where is he?
I'm not sure, but he could be in the car.
Come in.
Mr. Leibovitz, Mr. Armstrong to see you.
Good afternoon, Mr. Armstrong. Good afternoon. I'm very sorry to hear about the death of your brother.
Thank you.
Hey, please take a seat. Thanks, Melanie. Now, I understand you have some queries regarding his death and some concerns about the treatment that was provided to him.
Well, yes. I haven't been able to find out anything. I've spoken with the ambulance service, and they won't tell me anything. I've also spoken with the medical director at the Hanover Hospital, and he seemed to me to have been very evasive. Now, that's made me suspicious. So I've thought about it, and I think there was something wrong with the way my brother was treated. The others involved in the accident seemed to think that he wasn't that badly hurt. And then within 2 days, he passed away. I guess all I want to do is just get it clear in my mind. I just want to find out more about what happened to him.
Okay, well, we can attend to that very easily, Mr. Armstrong. The records of the ambulance service and the hospital records are both subject to the Freedom of Information Act. Now, all it will require is for me to have my secretary complete an authority for you to sign, which we will then send to the ambulance service and the hospital. There is a cost for this, of course. You'll have to pay for the Freedom of Information search to be carried out. But the ambulance service and the hospital are both obliged by law to provide you with copies of the records they compiled concerning the treatment provided to your brother. They will have to provide that material within 42 days.
Okay.
Now, once we've obtained those copy reports, we can sit down and examine them. It may then be necessary to obtain some consultant opinion about the treatment provided to your brother, but we can discuss that further when we've received the records.
Well, does that mean that the notes completed by the ambulance officers will also be made available to us?
Yes, why?
Well, I got the impression from a phone call I made to the hospital whilst Peter was being admitted that everything was okay. Whoever I spoke to said he was going to be fine.
Can you remember who it was you spoke to when you phoned?
Well, no. I was upset, you know. It was certainly the casualty department. But whoever it was just seemed to want to fob me off.
Mm-hmm.
Look, that's the impression I got.
Okay, well, I've made a note of that, Mr. Armstrong. We can take that further when we receive the documents from the ambulance service and the hospital. Did you, by any chance, get the name of the ambulance officer who treated your brother?
No, I didn't.
All right, that's okay. Those details will be part of the documents which we'll get from the ambulance service anyway.
G'day, Sarge. Business or pleasure?
Bit of both today, Dwayne.
Okay, then we'll come on down, we'll have a cuppa. So how's the wife?
Well, mate, she's going to go through with it. And I guess I'll have to stick by her.
Well, that was to be expected. Still, what can you do? So, what's this all about?
It's about a job you did back in May 1991. You know the Armstrong case? Well, it appears it's going to the coroner's court, and it's a summons for you to attend.
Well, is there some problem?
Hang on.
Is there something I didn't do?
It's about a comment you made on the patient care record.
Well, I don't recall the case details. I'll have to check with the logbook and hunt up the PCR.
April this year. And now for the local news. Today in the Coroner's Court, evidence was presented in the case concerning Peter Armstrong, who died of injuries sustained as a result of a motor vehicle accident in May 1991. Following the coronial inquiry...
You have given evidence that you attended at the scene of the accident in which the deceased suffered injury, correct?
Yes, that's correct.
In that evidence, you indicated that you believe the accident was caused by the deceased and that he was drunk at the time of the accident.
Yes, that's right.
What is the basis for you having formed those opinions, Mr. Depler?
Well, I looked in the PCR, the patient care record, and that's what it says there.
Well, what do you mean that's what's written in it? Don't you remember what happened?
Well, no, I don't really. I've attended that many accidents over the last 18 months that they all tend to look a bit the same. But the PCR notes record that the patient was drunk and he caused the accident.
Do you have the PCR in front of you?
Yes, I do.
Well, let's have a look at it then, shall we? Now then, there is one signature on the PCR. Is it yours, Mr. Depler?
Yes, it is.
Well then, can you explain to me why the handwriting in one part of the PCR is different from the other part?
Well, only that perhaps my partner filled out some of it and I filled out the rest.
Who was your partner?
According to the PCR, it was Frances Sorensen.
And have you discussed this matter with her?
No, I haven't. She moved out of the region some time ago. I'm not really sure where she is.
Well, which part did you fill in?
Well, most of it.
When did you fill it in? Immediately after the patient was delivered to hospital or at some other time?
Well, I'm not sure.
Well, when do you usually fill your reports in?
Well, it depends. We don't always have time to do it on the way to the hospital, and sometimes we have to do it later.
Can you be sure at all when you fill this one in?
No, I can't.
On what basis do you say that the patient was drunk?
Well, I thought he was drunk because he smelled of alcohol. That's what the PCR says.
Did the patient smell of alcohol, Mr. Depler, or did his clothes smell of alcohol?
I'm not sure.
Now, what if I told you that the patient's blood alcohol level was found to be less than 0.02? And what if I also told you that after the accident, the remains of a bottle of brandy was found under the patient's seat, and the patient's clothes, which he was wearing at the time of the accident, were subsequently analysed and found to have been wet with the brandy from the broken bottle? Would that change your opinion that the patient was drunk at the time of the accident?
Yes, I guess it could. But I don't recall any bottle of brandy.
I don't think there's very much you can remember, Mr. Depler.
Your Worship, I object to that remark.
Yes, Mr. Leibovitz.
Okay. Was there anything else that led you to believe that the patient was drunk?
No, just that he smelled of alcohol.
Well, what was the basis of your opinion that the patient's driving caused the accident? That is what you seem to be suggesting in the PCR.
Yeah, I just assumed that because he was drunk that he caused the accident.
Well, having heard what I have told you about the patient's blood alcohol level and the bottle of brandy in the car, who do you say is now responsible for causing the accident?
I guess I'm not really sure who caused the accident.
Thank you, Mr. Depler. Your evidence has been very helpful.
You have just seen an example of how problems might eventuate in court through poor attention to the details on the PCR. The examples which you have now seen demonstrate the reason for which we emphasise that the completion of the patient care record must be factual, accurate, complete and timely. If they do not measure up to that acronym of FACT, the ambulance officer who completes them may find himself in trouble, as did Dwayne Depler, when he came to give evidence in the coroner's court. A few simple points. You should ensure that your writing is legible so that people who subsequently examine the PCR do not have difficulty in deciphering it. There is nothing worse than having to spend substantial periods of time trying to unravel poor documentation. The material which you record should be accurate and complete. To ensure that it is accurate and complete, the PCR should be filled out as soon as possible after the treatment is provided to the patient. If you cannot fill in the PCR whilst the patient is being transported, it should be completed immediately thereafter. Circumstances will often arise which mean there is a delay in completing the PCR, but the fact that you have finished your shift and want to get home should not prevent you from completing the PCR for your most recent attendance. Where possible, you should complete the PCR entirely yourself. If you cannot do so, you should ensure that your partner signs that part completed by him or her, and the different parts of the PCR completed by the different officers should be clearly delineated. If you are provided with some information whilst attending a patient which is relevant to the cause of the patient's injuries, you should include in the PCR the source of the information in order that that source may be later checked by whoever happens to examine the PCR. By recording the source of the information, you can overcome what would otherwise be an embarrassment presented by a recording of hearsay information. Finally, you should regard the PCR as your record of what went on in a particular case. By looking at it sometime in the future, you should be able to refresh your memory as to precisely what happened. If you cannot do so, then you have not adequately completed the PCR. To help you more fully understand some of the material presented in this video, the in-service training officers have provided us with key questions for discussion. I have with me in the studio today Peter Hewitt from AOTC, Michael Proud, solicitor from Phillips Fox, Dr. Frank Archer, Ambulance Services Medical Officer, and Peter Brown, ASDAT from South Eastern Region. Welcome, gentlemen. Our first question, if a patient is not transported, especially if the attending officers believe that the patient should be transported, what details should be recorded on the patient care record? Peter.
Well, Chris, obviously all relevant details to the case are important to be recorded, despite the fact that the patient hasn't been transported, in particular the detail relating to any treatment that was initiated, as well as a statement indicating the reason for the refusal for transport, or the reason why the patient wasn't transported.
Well, is there any particular situation where a patient care record shouldn't be filled out, Peter?
No, certainly not, Chris. I think in any circumstance where an ambulance responds to an event, then details should be recorded, even if it is service not required or patient refusing transport. All actions that were taken at the scene should be certainly documented in the event of a problem down the track.
Well, we've been stressing in this video program the need to fill out a PCR legibly, accurately and comprehensively. What legal action could be taken against an ambulance officer for failing to complete a PCR correctly? Michael, I guess you should answer.
Well, it's a simple answer, Chris. None.
Mm-hmm.
But there is a gloss on it. If the PCR isn't completed and the actions of the ambulance officer are subsequently examined by a court, the ambulance officer who didn't fill in the PCR may have to explain to the court why he didn't fill it in. And it may be a lot easier for him to explain what he did at the time rather than to try and explain the difficult question of why the PCR wasn't completed.
So the repercussions may be quite far-reaching.
Yes, that's right.
And we've discussed the time-lapse situation. How long is it likely to be before an ambulance officer may be required to remember the content and detail of a PCR?
Well, in the case of a coronial inquest, probably only a matter of 6 to 9 months. But if there's civil litigation arising out of the treatment provided to a patient, it may be a number of years, possibly 3 or 4. The courts are very logged down at the moment.
What do you think an ambulance officer is likely to remember the details of that length of time, Peter?
Well, certainly not, Chris, in most circumstances, unless the event was something absolutely earth-shattering that really sticks in your mind. Most regular events really pale into the back of your mind, and it's very hard to remember the concise details, particularly if it is a court situation where precise information may be required. Hence, failure to fill out the PCR then puts you in a very awkward position.
Another area that we need to look at is that of a medical officer that may give advice to the ambulance officers, maybe about treatment to a patient that they feel shouldn't be given, and then in transit that patient begins to deteriorate in their condition, and the ambulance officer may feel the need to initiate the very treatment that the doctor has advised against. Frank, what should happen in that situation?
Well, there's no question, Chris, that if the patient's condition has changed in that period of time, that the ambulance officer has a duty of care to undertake their assessment, to come to a judgment, to plan management, and if that management includes, according to ambulance training and protocols, a treatment regime which is different or even contrary to what the doctor advised, then the ambulance officer is obliged to follow it through. But I think that prior to getting into that circumstance, the ambulance officer should take some insurance policies by, at the scene, asking the doctor why such treatment was perhaps not required, particularly if it's contrary to current ambulance practice. Secondly, to ask the question, what might happen during transport? In other words, anticipate some what-ifs. And I would think that most general practitioners would be quite happy to answer those questions and clarify for the ambulance officer to this ambulance officer's satisfaction and give guidance for transport and treatment during transport should that occur.
Well, Michael, let's clarify that. From a legal point of view, there's no complications if an ambulance officer does what they feel is necessary, even if that's contrary to the doctor's advice?
Well, there may be complications, but the ambulance officer's situation can be explained, and all he has to do is act in a manner which is reasonable for an ambulance officer in his position. And if the position is that the situation has changed and he feels that other treatment is appropriate, then he can embark on that treatment, and providing he does what a reasonable ambulance officer would do, then he should not be criticised for doing it.
Michael, what about the situation where the ambulance officer believes that what the doctor or perhaps another ambulance officer is doing is clearly wrong and so far outside anybody's protocols that it may endanger the patient's life? What should their action be in that sort of case?
Well, they should be challenged about it so that, if nothing else, the ambulance officer can record in his PCR that he did challenge the doctor about the treatment that was being prescribed and was told that it was appropriate and that was what was going to be done.
But in relationship to internal processes, then it would be appropriate, I would think, for the ambulance officer then through normal audit to refer the matter through the service medical officer rather than necessarily pursue that through any other avenue.
I think we should just follow this through a bit further because, Peter, you raised an interesting point. What if a doctor was prescribing some course of action that the ambulance officer really did feel very, very uncomfortable about. Frank, what would you advise in that situation?
Well, the first point would be to just question the doctor, I think, as Michael said. And generally speaking, this raises a doubt. And sometimes the doctor will pause, say, sorry, well, what would you suggest? Or, no, that's what I want. I think we need to be a little cautious about causing too much of a challenge, because there may well be a very valid reason for doing this. But again, the general practitioner in most circumstances would be happy to explain that. The question I want to put to Michael, however, is whether the ambulance officer can refuse to carry out that treatment or refuse to let the doctor use the equipment on the ambulance, be it a drug or a defibrillator or some item of equipment.
Well, the answers to the questions are, one, yes, he can refuse the treatment, because if in his view the treatment's going to prejudice the patient's condition or even be lethal, obviously he can't embark on that treatment. He can't refuse to let the doctor have access to the equipment. So if the doctor's perhaps prescribing a drug in a dosage which the ambulance officer knows to be lethal, he should say, well, here's the syringe and here's the drug, it's all yours. But he shouldn't say you can't use the equipment.
Well, then, in regard to the patient care record, what should be done there, Frank?
Well, I think, Chris, that's clearly quite appropriate for the ambulance officer then to ask the doctor to sign on the appropriate section of the patient care record for the treatment that they carried out, or the treatment that they were ordering in the earlier scenario, and then get the doctor to sign it. I think that's the only option that the ambulance officer's got. Provides the accountability focus back on the doctor and provides the ambulance service with a record and clarifies the situation with respect to the ambulance officer.
So the ambulance officer has the right to question the doctor's advice, has the right to require that the doctor maybe follow through any instructions that they feel uncomfortable with, but they're not in a position to refuse the doctor any use of their facilities that they have on site. And the patient care record enables them to have an accurate documentation, even with the doctor's signature attached. Okay, well, the next question to look at is that.
Here's the letter.
Thanks, Mr. Nelson.
We'll look after her. Car 54 loaded, 1 female, signal 2 to Thistlethwaite Hospital.
Roger. Receive car 54.
Mrs. Nelson, how are you feeling now? Mrs. Nelson? Can you hear me? Mrs. Nelson? Mrs. Nelson? Dwayne, she's not responding. Can you pull over and give us a hand? You all right?
Yep.
Right. Oh, shit. Yep.
Do you want an airway?
Yeah, thanks.
Okay, you right now?
Yeah, you better make it a 5-1.
Okay, what have we got?
We've got a 33-year-old female, altered conscious state. She's responding only to pain.
Car 54, we now have a signal 5-1.
Car 54.
Case number 312 is now a signal 5-1.
All cars stand by. Car 54, give you details.
You've just viewed what is essentially a routine case, an example of the sort of activity that an ambulance officer could expect to undertake every working day. However, one of the actions undertaken by one of the ambulance officers in this scene may be subject to some question. Let's go back to the scene and see what develops.
That's right. The letter. Maybe they could give me some answers as to why she's unconscious. Why not? I'll open it and have a look.
We are now going to look at one final scene concerning another medico-legal aspect and how this can affect the performance of your duties.
Is this for your doctor? Do you mind if I take it? Oh, thank you. Now what we're going to do is to get you to sit on here. Okay? Okay. And step. Step.
Just lie back there for us, Mr. Stone.
My bag.
Oh, yes, I've got your bag. Here we go. Good.
Hey, what's going on here? Where are you taking me,
Calm
Nan?
down, mate. We're taking your grandmother to hospital.
Look, I'm sick of this. It seems like everyone wants to put Nan in hospital.
Well, her doctor's authorised the transportation.
She's not going anywhere. I've got enduring power of attorney. She's not going, okay?
Let me explain the enduring power of attorney. Pursuant to the provisions of the Medical Treatment Enduring Power of Attorney Act, a decision about the medical treatment of a person may be made by a person appointed as an agent in accordance with the provisions of the legislation, or in some circumstances, by a guardian, if a guardian has been appointed under the Guardianship and Administration Board Act 1986. The appointment of an agent must be in accordance with the form in the Act and must be witnessed by two persons. The appointment of the agent takes effect if and only if the person giving the power becomes incompetent. Once an agent has been appointed pursuant to the Act, the opinion of a medical practitioner and another person are required before decisions can be made concerning the patient's medical treatment. The medical practitioner and another person must be satisfied that the patient's agent has been informed about the nature of the patient's current condition to an extent that would be reasonably sufficient to enable the patient, if he or she were competent, to make a decision about whether or not to refuse medical treatment generally or of a particular kind for that condition. The medical practitioner and the other person must also be satisfied that the agent or guardian understand the information. Once they are so satisfied, the agent or guardian may, on behalf of the patient, refuse medical treatment generally or refuse medical treatment of a particular kind for the condition from which the patient suffers. Okay, well, the next question to look at is that of maybe one of the relatives interfering with the process. What's the ambulance officer's legal position if requested by a relative not to resuscitate a patient? Okay.
It's a difficult question. There may be the unusual circumstance where the relative holds an enduring power of attorney from the patient, which enables that person holding the power of attorney to make decisions about the patient's medical treatment. But in the absence of that document, the request of the relative has no legal effect on the ambulance officer, and it becomes a matter of the ambulance officer making a judgment as to what treatment is appropriate for the patient. It's really an ethical question which the medical profession can probably answer better than I.
Well, Frank?
Thank you, Michael. I think the situation legally, Michael's explained clearly. A difficult situation arises when the ambulance officer is placed in that situation, and we could put it in a situation where the patient is perhaps clearly terminal or pre-terminal, and I think that situation needs to be handled with dignity, with respect for both the patient, for the relatives, and with good communication skills by the ambulance officer. In the situation, I think the ambulance officer may say, well, this patient requires some care, some attention at this moment, which is not too interventionist. And I think that's a good balance between the two. The patient may need to be transported because the ambulance officer can't stop treatment if the patient is not dead yet and not certified, if the patient requires continuing care. But I think you can find a line between no care, aggressive care, and a balance of sort of palliative minimum level of care.
Okay, anyone else want to comment on that question? Because I think we need to clarify how to respond to the interference of relatives. Have we covered that well enough?
Look at it from the point of view of a situation where the relative is aggressive, and it may not necessarily be a situation of terminal illness, but sudden arrest, and the views held by that family are certainly that relatives of this family will die with dignity. There is no enduring power of attorney or any other documentation which enables us to therefore make the right sorts of legal type decisions. Where do we stand then in relationship, particularly Mike, I suppose, with this relative saying, with this patient who can't respond anyway, this relative saying, don't resuscitate, 40-year-old person?
Well, the ambulance officer has a duty of care to provide care to the patient, and that's the primary duty. He has to take into account what's being said by the relatives, but the request by the relatives isn't going to be an answer later on if he doesn't take the necessary steps to provide the care to the patient and the patient dies. He'll have to explain his actions at some stage, and his primary duty is to provide care to the patient.
And then back to the patient care record, that kind of objection, that kind of obstruction, whatever form it takes, should be recorded as well amongst all the other notes on the PCR.
Can I perhaps just take that one step further to where the relative is actually a parent of a child, and for whatever reason the parent doesn't want us as ambulance officers to treat the child any further? What would be the situation there?
There's legislative power to the ambulance officer to provide the treatment to the child, despite either the absence of or the contrary wishes of the parents. You are covered, so that if you think the treatment is necessary, you can embark on that course of action.
So it does seem to be that the ambulance officer is obligated to give care unless they have documented proof that an enduring power of attorney has been properly followed through, and that frustrates them. Otherwise, they really are obligated, unless they feel, as Frank was mentioning, they feel for other considerations not to follow through. And there they would still be obligated to give at least a minimal level of care. Okay, well, what other questions or comments might you feel are necessary to make about the PCR to clarify for our viewers? Frank, I think you had a thought.
One of the observations I've made by doing the clinical audit within the ambulance service is when I review a particular case with an ambulance officer, often I get in the situation where the officer will say, yes, well, Frank, I know that's what I've written, but that's not what I really did. And I can understand how from time to time these occur, in the sense that there's pressure, for example, for the officer to get on to the next case. But I wonder if Michael might like to comment on where that leaves the ambulance officer in a legal situation.
Well, he could be in a difficult position if he has to refer to the patient care record in litigation some way down the track and says, well, the PCR says this, but that's not actually what I did. And he will then have to explain the discrepancy. And it's probably better for him early on to go back to the PCR and amend it and make a clear notation on it that he amended it on a particular date and the changes are being recorded for a particular reason, so that he doesn't have to make the explanation later on. He can make it clear that he recalled that there were some changes that were necessary and he went and did them as soon as possible. I think that's the best way of dealing with it. Otherwise, it is very difficult to explain what you did and not what you recorded.
Peter?
Further complication to that, then, if he has made this amendment and the hospital copy was the previous copy, we now have two documents, one which has been amended and one which was the original. Will the real document please stand up?
Well, it will. It'll be an absolute smorgasbord for the barrister who's appearing for whoever's having a crack at the ambulance officer. But it is capable of explanation, and we've catered with this situation in court at different times, and providing the ambulance officer makes a credible witness, his explanation of the difference in the documents will be accepted.
Would it be appropriate in that circumstance for the officer to just make a note of the differences that may appear on the hospital copy?
I certainly should make it quite clear on the original PCR at least. It may not be practical for him to go to the hospital to amend the hospital copy, but on the original PCR he should make it quite clear that he is amending it and put the date on which he's amended it.
Now, as I understand that then, we have a problem where sometimes an ambulance officer can go to a hospital, deliver a patient that's been transported and not necessarily have the form completed. Leave with the hospital even there a half-complete form and take the rest back. And you're saying that shouldn't create any legal complications?
No, it should be, if it's done properly, capable of reasonable explanation.
The other question then is that of why does a person write down something which they'd later tell you, Frank, that isn't exactly what happened? Are they relying on stereotype statements, or are they abbreviating too much? How can that be addressed?
I think it's a matter of recall to some degree. Secondly, in the matter of a multi-treatment situation, you don't always remember precisely in which steps. But there are some strategies that can be taken. For example, a common error is to summate your management. For example, in giving a patient salbutamol or some other drug, then in writing on the patient care record, they summate all of the salbutamol in one line. In fact, that's not the treatment. The treatment is this much, 10 minutes later this much, and 10 minutes later that much. And I think what needs to be written down is as clear as possible, to be precise about the actions taken in the sequence that they were taken, so that the time and the accuracy are quite clearly there.
Any other comments that you want to make, General? Did you have a comment down there, Peter?
Well, I think perhaps one of the things we need to just remember in all this is that really the standard of patient care record completion has improved markedly, I think, probably over the last 5 to 10 years, but certainly since the introduction of the new style of PCR. And I think that's been very encouraging. I think ambulance officers now are much more aware of a need to fill out the record, and it's probably more a case now of starting to fine-tune to some of the little specifics, and just so that if we do end up in the situation where we're in court in 5 years' time or whenever, that we've got a good, accurate record we can turn back to, that isn't going to incriminate us and will be of benefit to us, the service, and ultimately to our patients and anybody else as well.
I think that's a good point to make. At the moment, we are being maybe a little dramatic about the whole thing. We're bringing it to people's attention. What is the real state of play at the moment, Michael?
In terms of litigation, there's been an increase over the last 10 or 15 years generally of litigation against professionals generally, and the medical profession hasn't escaped from that litigation. By properly documenting your PCRs, the amount of risk involved in that litigation for the ambulance service can be minimised.
And Frank, then, as ambulance services medical officer, what's your assessment of the present state of things?
I think I'd agree with Peter quite clearly. There's been a very significant improvement in the quality of patient care records. And the other thing that I'm most impressed and would like to commend and acknowledge is that there's now an increasing incidence across the state of ambulance officers who, for one reason or another, have made an error of judgment, or perhaps given a wrong dose of salbutamol, too much, too little, or GTN, for example, and they're actually bringing this to the attention of their station officer and to their medical officer as a part of clinical audit. And I think that's an appropriate sign of increasing maturity and professionalism within ambulance. Nobody is ever perfect. We aim to be as precise as we possibly can. And I think that when these events occur, they need to be acknowledged, they need to be written on a patient care record, because that's what happened. They then need to be audited and followed through appropriately. And Michael, how would that be handled, for example, if an ambulance officer wrote on his patient care record that he gave too much salbutamol or a dose of GTN, perhaps when it was mildly contraindicated?
There's no penalty for telling the truth, and it's better for the truth to be recorded in the PCR rather than have it dragged out of an ambulance officer in a court of law somewhere down the track. There may be ramifications for the ambulance service and its insurers in terms of liability for a claim, but the truth should be recorded.
Good. Well, Peter, do you have a question?
The situation where a patient refuses transport, and one of the things we've been doing in the past is encouraging ambulance officers to get the PCR signed by the patient to say they have refused. Does this give the ambulance officer indemnity from prosecution or some legal action further down the track?
No, it doesn't give indemnity, but what it does is provide a very good record of what happened and a very good explanation, and it may well be a complete excuse.
You think it's a good idea then to get the patient to sign?
Certainly.
Okay. Well, Frank, does that cover everything for us?
I think that's a nice and clear explanation, but I think there's another medical component, and that is that we can't just walk out of our responsibility. If we feel that the patient requires further care at that point, then I think we have a responsibility to arrange that care in an alternative strategy to transport. That might mean calling a locum if there's a locum around. It might mean phoning the general practitioner to notify or to get them to do a house visit. It might mean waiting for a relative to arrive. If there's some danger to the patient, either physically or clinically, I believe that we can't leave the scene until there is some appropriate follow-up arranged and clearly in place. It may even get to the extent that if the situation falls within the province and the definition of the Mental Health Act, that we may be in the position to call police to help facilitate. But that's only a minority of cases, but is an option. But I think it's very important that getting a patient or a witness to sign the patient care record is not necessarily the end point. We have a duty of care to ensure that that patient gets the right care and that we have a responsibility to arrange follow-up, or at least make sure that that follow-up process is in train, and if the patient is in danger, we stay there until that appropriate care is followed through.
Good.
There would also be a legal requirement there, I would imagine, to fully inform the patient prior to getting their signature of exactly what you believe the problem is, not just have the patient say, I don't want to go, okay, sign the PCR and let's get in our vehicle and go.
Yes, that's right, Peter. The explanation should be given to the patient as to the ramifications of refusing the treatment, and of course that should be recorded so that it can be shown later on the patient was given that explanation.
Good. Well, gentlemen, I think we've covered a lot of ground today, and thank you for your time. The importance of completing PCRs in a legible, accurate and comprehensive manner cannot be overemphasised. Factual, accurate, complete, timely.